Welcome to Lawton Online with your host, Andrew Lawton. He's locked, loaded, and ready to fire. Lawton Online starts right now.
Hello and welcome to you. This is Lawton Online here on the Rebel.media. My name is Andrew Lawton, and it's so great to have you tuned into the program, as always here. I hope, as always, if you're a first-time listener, welcome. If you are a repeat listener, what's wrong with you? I mean, welcome back. Sorry, wrong notes there. Keep listening. So great to talk to you again. I'm going to focus a little bit this program on issues that are political, but not about politics. Bear with me here, because being a full-time broadcaster, I have a daily radio show as well as this podcast, and I also do a lot of interviews as well. People will always ask me, if they're not familiar with my work or whatnot, what's your show about? And I always sort of laugh it off. I say, well, it depends on what's happening. Depends on what the issue of the day is, the topic du jour, if you will. But it has forced me to, in a very good way, to have to sit back and evaluate, okay, what is this show about? I mean, it's about conservatism, it's about the culture war, it's about basically what's happening in the world and trying to find a sensible response to that and sensible interpretation of it. But at the core, it's a question of what I believe, what's important to me. And when I internalize that question, ultimately my show is about freedom. Freedom to speak. Freedom to own property, freedom to debate, to challenge, freedom to focus on your own well-being, your own economic growth without the government stymieing that. These are all very distinct issues, but freedom seems to be that overarching banner, that umbrella that unites them. And this particular episode of the show is going to have a much more direct line to the questions of freedom. We're going to be talking about a lot of issues on this show, not all of them. In fact, most of them have been flying under the radar. They haven't gotten much, if at all, coverage in the mainstream media, or they've gotten very limited coverage at best. And that speaks to the broader issue here, that so many people are ignorant to the infringements and threats of our freedoms, what little freedoms we have left, by the way, that seem to exist in this day, in 2016. So that's going to be a guiding theme for this show. And I'll also give you a bit of a preview here. I'm going to be next week joined on the program by Lars Hedegaard from the Denmark Free Press Society, a journalist and author who's fended off an assassination attempt. Again, a man who still defiantly speaks out in support of free speech. That interview is going to be on next week's podcast, and I'm so looking forward to it. I'm expecting it to be an absolutely wonderful one. Hasn't happened yet, but don't worry, you will hear it when it happens, because that one, again, not something you will hear at all in the mainstream media. But I wanted to begin on the program by talking about, again, when we discuss this question of free speech here, I want to talk about a little bit of a frustrating story. It's not a little bit frustrating, it's very frustrating. And this is civil forfeiture. Now, this sounds like a very wonky term. It sounds very dense, but bear with me here, because if you're not familiar with the concept or with the fact that it exists or the rules surrounding it, I can probably guarantee you that in 20 minutes, you will be even more outraged at your government than you already are. This is your money-back guarantee. I mean, it's a free podcast, so that doesn't really amount to a hill of beans. But I think you will be even more outraged about your government, because I fancy myself a little bit of a jack of all trades, if you will. I try to know and keep tabs on things that are happening in all different areas. I try to know a little bit of everything. I mean, it's talk radio. You have to be well-versed in a number of subjects. I had not heard of this. I knew about individual cases where it happened, but I had not heard of this. And in a nutshell, and I'm going to have a guest on in just a moment to explain a bit more about this, civil forfeiture is the government, usually the provincial government, taking your property, taking your cash, or taking a physical piece of property and then selling it and using that money for, well, heavens knows what. And this is something that has been addressed in a recent report done by a partnership between two organizations, the Canadian Constitution Foundation and also the Institute for Liberal Studies. And they've looked at not just the wide variety of types of laws and types of enforcement that exist across the country, but more importantly, the national epidemic, if you will, of governments laying claim to your property and to my property, or having the right to do so, even if we've done absolutely nothing wrong. Joining me on the line is Derek James Fromm. He is a lawyer with the CCF, the Canadian Constitution Foundation, but also he is the co-author of this report on civil forfeiture, which has really cemented itself as a must-read, and it's done in very attainable language. You don't need to be a lawyer or a professor to get it. Derek, it's great to talk to you, sir. Thanks for having the time. I mean, we've talked about other issues on the show related to property rights, but I appreciate you coming on for this as well, sir, so thank you.
You're welcome.
So we were chatting a little bit before when we were just setting up the interview about how this is such a unique topic because it's one of those ones that not a lot of people know about, but when people start to realize what exactly civil forfeiture is and what its place is in Canada and in the provinces across the country, it seems to be getting a lot of people very upset about how things are. So I think it's incredible that it's taken this long for someone to really spark this discussion. So I'm glad you've done that.
Oh, well, thank you.
So let's talk for starters here, because let's assume this is an introduction for a lot of people to the actual concept here. What is civil forfeiture?
Well, civil forfeiture is a special process that provincial governments use to take people's property from them. And the property that they can take is property that's been either used to commit an illegal act or is the proceeds of an illegal act. And so that basically means that, a lot to explain there. Illegal act in Ontario, for instance, means any sort of criminal activity, drug-related activity, or even provincial offenses. It's very, very broad. So if you're breaking a law, it's an illegal act. And so all you then have to think about is what property have you used to commit an illegal act? If you're speeding, your car is the instrument of an illegal act. Now, proceeds is more clear. So if you benefit from any sort of an illegal act and then use that benefit to acquire property, that property also can be claimed by the provincial civil forfeiture office.
And we've seen cases where in the past, and I don't know if these are outliers or not, where people have been cleared of charges even, but they haven't regained the property that was seized under this.
You know what? That's really not an outlier. Some of the acts in Canada and the study that I co-authored, we looked at all the provincial acts that are in existence right now in Canada. There's 8 of them. Some of those acts, like for instance, New Brunswick's law, actually explicitly says in it that you don't have to have done, you don't have to be convicted of anything illegal, and you can still face criminal or the civil forfeiture proceedings. And in fact, it does say in it that you can even be acquitted and then still face these sorts of proceedings.
How much of a variance is there between the different laws in provinces across the country? Are there some that have better laws than others, or is this a weak point in pretty much the whole country?
Well, it's a weak point, but there is variation. Now, for instance, when we looked at the laws of Canada, we decided that one of the important things that we wanted to distinguish the laws from each other on was how much discretion was afforded to judges. Now, a judge is a very well-trained individual who can look at particular facts before him or her and say, this is not an appropriate circumstance for this person to lose their property. And if judges have the discretion to decide on a case-by-case basis what is appropriate and how much property the person should lose in a civil forfeiture proceeding, we considered that a good thing. Some provinces have very little discretion. For instance, Ontario. Ontario, judges have very, very limited discretion. The words like shall and, unless the judge shall forfeit this property, unless it's clearly not in the interests of justice. This sets a very, very high bar and makes it very difficult for people to prove that a forfeiture order would be unfair to them. But now other provinces like Alberta's civil forfeiture regime has much more discretion built into it. And so for that, we graded Alberta's higher than Ontario's.
I know there are some examples that governments would use to defend this, like, for example, police that, do a raid of a gang or biker gang clubhouse and the government then seizes the clubhouse. I mean, these are areas where you can debate the merits of it, but these are the ones that are held up that most people are going to say, okay, yeah, that's probably, a reasonable enough approach. But then you look at other cases where it seems to be much more of an overreach, like, for instance, a man in Saskatchewan who sold $60 worth of OxyContin that he legally owned to buy gas so he could drive to work, and then the government seized his truck, which was valued at $7,500. Or one in Ontario where a 12-unit apartment building was seized because not the couple did anything wrong, but tenants in the building were involved in illegal activities.
Yeah, and that sort of thing is increasingly common, sad to say, and it's happening all over the place. You can just Google Civil Forfeiture Canada, and you'll see a whole bunch of things pop up in your news feed. For instance, I came across a civil forfeiture of a woman from Vancouver who was a heroin addict and had done heroin in her house. So what's the just response by the wise people in the civil forfeiture office? Well, you know what? We should make her homeless by seizing her house. So now she's a homeless heroin addict living in Vancouver. Is that really a good result? But you know what the thing is here is that it's all about incentives. In my opinion, this is all about incentives. The civil forfeiture legislation everywhere in Canada incentivizes enforcement to go after valuable assets. So if they can turn around and acquire valuable assets from people and then liquidate that asset, and then that money goes back into enforcement, back into the civil forfeiture office, potentially to the police. We don't know because we're unable to really tell because they're not transparent. But that's what happens. So then what happens to the police when they're out on the street? Well, there's violent crime happening over there, but it doesn't involve any property that we can seize and liquidate and profit from ourselves. But you know what? There's a guy over here committing a traffic offense with a Ferrari that we can seize and sell, and we'll profit from that. And so, that's what ends up happening is it creates these sort of perverse incentives for enforcement to go after valuable property. And the other thing that's very problematic about this, in that sense, is that it keeps police from doing the job that they're supposed to, keeping the public safe, because they're always looking for the assets. What it does is it occupies their time and keeps them from going after, actual criminal activity where people are harmed.
Yeah, it turns law enforcement agencies into Craigslist flippers where they're just buying and selling things or actually taking and selling things rather than they're actually keeping people safe. So what is the money in the letter of the law supposed to be going towards?
Well, every piece of legislation in Canada, I think other than Saskatchewan's, if I remember correctly right now, has purposes listed at the beginning of the act. And generally speaking, they all kind of fall into this category. Civil forfeiture is intended to deter crime and to provide compensation for victims. And now this is so interesting because it's doing neither of those two things. The deterrence of crime, well, my colleague Karen Selleck pointed out in 2001, before Ontario brought their legislation in, she pointed out in a special hearing that what this does is actually makes the province of Ontario a silent partner in organized crime. Now, that sounds really strange to begin with, but think of it this way. And Ontario benefits when organized crime or criminals have property that's valuable that can be seized and sold. So Ontario now has an interest in having organized crime make money and get property so that it can be seized and sold. She had that criticism in place, and it's turned out to be correct over time, because what's ended up happening is it's created these perverse incentives where Ontario now goes after valuable assets and seizes them from people that it thinks it can, will put up little resistance. So the deterrent side doesn't really work. And there's evidence, papers being written on this from the UK, from the United States, and from Australia, where similar regimes are in place. And the results of those studies are that, look, civil forfeiture has almost no effect on organized crime, because organized crime is sophisticated enough to stay one step ahead of law enforcement. Who is targeted? Well, it's the people who, are renting out their apartments to people who grow pot. And you know what? They come in, they seize the entire apartment, and the landlords are actually innocent third parties to this. Those are the people that suffer. So there's that deterrent side. It does nothing to deter crime. But the other side is it's supposed to provide compensation to victims. And you can FOIP these people, and they won't give you an answer. In fact, we contacted the Alberta Civil Forfeiture Office, and they actually admitted they don't keep track of how much they take in and expend on an annual basis. So they're just completely unaccountable. It is a black box. We don't know what's happening. We have no idea. And they could be seizing, exorbitant amounts of money and just rolling it over into the next year's budget. We have no idea.
And I know that one board in particular that was noted, the Peel Region Police Board, used seized money to apparently buy tickets to mayoral galas.
Yeah. It's there's been some really interesting stuff out of the U.S. on this, where we got our laws from, where police enforcement, they'll seize things that they want. And BC, this happens too. Like, wow, this is a great truck. Well, we'll seize it and we'll turn it into a police truck. Or I think the most ludicrous one I've heard about is a margarita machine. So we shouldn't expect results different from this. The law is built in a way that incentivizes this type of behavior in law enforcement. We should expect them to behave this way.
When we look at the law itself, so you mentioned in Ontario it goes back to 2001, why was no one standing up and saying this is a gross violation of fundamental property rights, of rights to due process? Because even if you had the threshold as being you have to actually be convicted, whether it's a provincial or federal offense, it still seems like it would be an overreaching law. But we're dealing with a number of things that I think most Canadians would assume or would want to assume are rights, like the right to due process, like the right to basically a presumption of innocence, like the right to own property and manage your property, even though that is one we could probably debate is not that ingrained in Canadian culture. Yep. But why was no one stepping up and talking about these things before this legislation was passed?
Well, other than my colleague Karen, I'm not sure if any people were. Law professors were kind of incredulous about this, and so were many lawyers. But you're right. It was part of a larger political agenda that's really easy to sell to people. Look, this is all the politician has to say. There's bad people out there. They're harming people, and they're getting rich off the harm they cause. We want the power to be able to strip them of their profits and put it to good use by putting it back into enforcement and keeping you safe. That's all a politician has to say, and people will be move on with their lives and believe it. But it's simply not the case that it happens this way. And so, the first law was brought in 2001 in Ontario, and it was challenged soon afterwards and made it to the Supreme Court by 2009. And the Supreme Court held that this was constitutional legislation. They upheld the law in Ontario as constitutional. And their finding in this Chatterjee decision of 2009 was that the law wasn't punitive. It was just remedial in nature, which brings us to some of the recommendations we made in our report. Basically, that if the law was held by the Supreme Court to be remedial in nature, it should be providing remedy to people who have suffered. And at this point, it is not anywhere in Canada providing remedy to people who have suffered as a result of criminal activity. Therefore, I think the Supreme Court's Chatterjee decision should be re-examined in light of the actual facts on the ground right now.
Yeah, and I want to talk a little bit more about the recommendations in a moment here, but I just want to go through this scenario again because I want to make sure that people are very clear on just what we're dealing with here. Let's say that I were driving down a street in Toronto or London or Ottawa, whatever the case may be, and I was texting and driving. A police officer pulled me over. My car and my phone could be seized.
That is correct.
Now, does this happen at the roadside? Does this happen after the fact? Is there really any mechanism that governs what process this civil forfeiture needs to take?
The Act actually says that the Civil Forfeiture Office will make an application in court. And so you'll be notified that your property is going to be forfeited, and you'll have to, if you choose to appear in court, you can defend yourself against this. But it doesn't happen immediately on the roadside. Generally, what would happen in that case is they would seize the property and then move to make the application.
And what recourse is available to someone after that seizure has happened, after it's been determined that, yes, we can take this property from you?
Well, you can show up and defend yourself in the application. Now, in Ontario, you have a very difficult time because the judges have very little discretion in what they can do. But you would have to show that it was, quote, clearly not in the interests of justice for that forfeiture to happen. And currently, the case law defining what that is sets an extremely high bar. You're going to expend a lot of effort trying to do that.
So apart from eliminating the act altogether, what are some of the other improvements that you think could at least bring this more in line with protecting people's rights?
Well, the first thing that I think is important is that there has to be some correspondence between a conviction and the property seized and then ultimately forfeited. We can't be forfeiting property from people on the suspicion of an illegal act. Because what happens here, too, I probably haven't been clear about this, but this is an important point, too, is that this is a civil process, which means that the Civil Forfeiture Office needs only prove its case on the balance of probabilities. So let's say a 51% probability that you actually did do something illegal with the property. Now, if they were trying to do this in a criminal court, they would need to prove it beyond the balance of probabilities. Beyond a reasonable doubt. And so it's a much higher standard in the criminal courts. So what that does is it incentivizes them to go after your property rather than seek a criminal conviction. So we would like to see that people subject to forfeiture proceedings must first have gone to trial and been convicted of actually committing some sort of offense. Only then should forfeiture be available. Until then, nothing's been proven. The property should not be subject to forfeiture proceedings. That is a very important and key point that we're trying to make.
I can't wait until someone uses like their prosthetic leg to run away from the scene of a robbery or something, and all of a sudden the government's taken that off of them. It doesn't seem all that unrealistic given what you've told us about this.
Yeah, and the only thing keeping stuff like that from happening is not built into the law. The legislation would allow ludicrous things like that to happen, but no enforcement agency is going to try to do that because the political backlash would be so strong. So the result is that they have huge amounts of discretion in what they pursue. Now, just stop and think. Do you want to live in a country where law enforcement is predictable and rule-bound, or do you want to live in a country where law enforcement has so much discretion it appears to be arbitrary?
Yeah.
It's very important. So we don't want them to have a lot of discretion in how they apply this law.
Very well said. I'm joined on the line by Derek James Fromm, lawyer with the Canadian Constitution Foundation and co-author of a Civil Forfeiture in Canada report. We'll have a link to that up online. Derek, fascinating topic, a very terrifying one, but I still appreciate your work on this nonetheless. Thank you very much, sir.
Thank you.
Okay, I ended up talking to him for like twice as long as I thought I was going to. But did I make good on my promise at the beginning of this segment, at the beginning of this show? That if you were not already aware of that, you would be more outraged at the government than you were already. Now, it's possible that, like so many others, especially people I've heard from in the course of this podcast, you shrug your shoulders and go, yeah, this is just what they do. This is just what they do. And what's interesting is that we're not even looking at some old common law policy here. We're not even looking at some thing that's been on the books, since Confederation, and we sort of just kept it there because there wasn't the will to change it. We're talking about something the government actually has been putting in place for the last 15 years. And even though most of us would agree, okay, yes, if you're a drug dealer, maybe the government can seize your cash, seize your drugs. But you're a landlord? One of your tenants is, unbeknownst to you, selling drugs, growing drugs, and all of a sudden the rent money you get is seen as a proceed of crime? Even if everyone in the course of that is acquitted. And I know from talking to a number of my friends who own rental properties that it's already bad enough to be a landlord in Ontario. I know, and I'm sure other provinces have a very similar dilemma. It's already problematic enough. You already have your rights taken away. You already have so many things done to handicap you. It's not like you can just check up on your tenants without their knowledge or invitation. So how are you even supposed to know if someone is basically running a drug op in a facility they're renting from you? And that's just one example that speaks to how this puts bad people on the same level as good people, on the same level as people that have nothing to do with the bad people at all. And again, I think Derek closed with a very interesting question and a very important question in that interview, which is, do we want to be a society and a country where we have broad sweeping laws and just hope for the best? Just hope that police officers are not going to give the strictest interpretation possible when it was not the intent of the law? Or do we want due process? Do we want due diligence? This is not happening in a criminal court where you can defend yourself and appeal it. This is happening in a civil case, regardless of what's happened with an adjacent criminal case or with a related criminal case. And there was a little chuckle that Derek and I shared in the middle of that interview when I mentioned something about property rights, because let's face it, these are not things that exist in Canada. You know, I talk a lot of the time about property rights, but I'm painfully aware of the fact that when that subject arises, I'm talking about it in a theoretical context, or I'm talking about it in sort of moral rights, natural rights. I know that saying, hey, property rights as being a defense of anything, or a defense against any government encroachment, is not going to amount to a hill of beans, because let's face it, read our sham of a constitution from 1982, and you will not find those words anywhere. You won't find it. It simply does not exist in any sort of modern application that Canadians are guaranteed the right to their own property. And this is something that has caused so much more harm than good. And I'm so glad that this issue has been a little bit more mainstreamed by this report, because, again, I know intelligent people who had no idea that this was happening. In fact, I even saw a number of lawyers who were aware of it, but they hadn't studied it. It wasn't their specialty, so they didn't understand the scope of it. And even the Toronto Star, the Globe and Mail have both picked up that report. So it is getting some traction. Now, will government change it? That stands to be seen. That's a question for another day entirely. But my goodness, if this does not shatter your faith, what little faith may have been left in provincial governments, and this is not just a Kathleen Wynne issue or if you're in Ontario, it's not just a Rachel Notley issue if you're in Alberta. This is a systemic problem across the country that extends far past the boundaries of any political party. This is just big government at its best, and greedy government at its best. When we come back in just a couple of moments, more Lawton Online here on the rebel.media. I'm going to be shifting gears, talking about something that we could argue property rights plays into, although it's a bit more of a lighter subject, and it's about cleavage and short skirts. Have I gotten your attention? It's a shame it's not a visual show, right? In any case, we'll be right back, folks. Stay tuned. This is Lawton Online.
Email your thoughts to Andrew at andrewlawton.ca or tweet Andrew using @AndrewLawton.
It is 2016, and still the human rights commissions are desperately trying to cling to any notion that may be relevant in today's society, in today's country, in anything whatsoever. They are clinging to anything they can grasp. And they're irrelevant. They've always been irrelevant, even more so now. Unfortunately, these irrelevant agencies carry the full weight of the law in a lot of cases, are backed by taxpayer dollars to fight fruitless cases to protect human rights or so-called human rights that simply do not exist. You know, in the last segment, I was talking about property rights, rights that are so fundamental to any free society, and by extension, we must say rights that don't seem to exist in the government's eyes, but human rights commissions seem to believe that you have a fundamental right to be free from having your feelings hurt, to be free from being offended, to be free from someone saying a mean thing to you, someone doing a mean thing to you, or even someone doing nothing at all to you if you feel like that was bad. It's codified microaggressions. Well, this week, the Ontario Human Rights Commission sent down its big mandate tackling the big oppression of the era, the biggest women's rights issue since not being deemed a person, and that is servers and bartenders that have to wear short skirts. Yes. Did you realize that this was the biggest human rights battle, the biggest oppression, the cultural genocide, if you will, that exists this year? I didn't know it was that bad. Now, I go out to eat a lot. I travel a fair bit, so I see servers that have a wide variety of dress codes, from the skimpy, tight skirt, shirt, all that sort of stuff, up into people who are wearing long pants and opaque, baggy blouses. And to be perfectly candid, I'm not going to deny that sometimes eye candy is, as a human being, a desirable thing to see. To be honest, I just want you to get my order right, to bring me my food, to treat me nicely, and that's it. That's how I decide whether I'm impressed with service. That's how I decide if I'm going to tip well for the service. And I think most people are probably in that boat as well. Now you go to a place like Hooters, and yeah, you go for the wings, but maybe there's a bit more to it. Places like Moxie's in Canada, again, they always hire attractive people that are dressed in a way that shows off such attractiveness. But the great thing about it is that in a free country, no one is forced to work at a place like this. Businesses shouldn't be forced to hire anyone that works at a place like this. And if you own the business, you're signing the paychecks, it doesn't seem to be that unreasonable that you get to decide whether people are going to show up wearing pantyhose, high heels, and a short skirt, or whether they're going to show up in a Mickey Mouse costume. But the Human Rights Commission doesn't recognize that right for a business owner to decide what they want. So Renu Mandan, the new chief commissioner of the Human Rights Commission, has said that it is discriminatory and sexist for a sexualized dress code for females. Anything from requiring makeup to mandating tight skirts or low-cut tops, these are all discriminatory. She said this in general terms about all employers, but specifically mentioned the restaurant and bar industry, where we see this happening most often for obvious reasons. She says that 70% of the people that work in the food service industry are young women, so she said that this can lead to sexual harassment. She also said that a sexualized dress code can shut out people that practice a specific religious belief, where maybe skimpy clothing's not allowed, or transgendered people who don't want to wear any particular type of clothing because of the gender that they feel they are. So the director of the Human Rights Legal Support Center said, "Excellent customer service doesn't have a cup size," unquote. I'm sure we can take issue with that in a few different ways here, but I'll even bypass that. I want to focus more on a comment made by Commissioner Mandan about this. She said, when asked by the Toronto Sun's Antonella Artuso, why not let businesses decide dress codes in their place of employment? She said, quote, "That's precisely the point of the Human Rights Code. The code protects against discrimination even where there might be a business case for discrimination. The point of the Human Rights Code is to actually be a countervailing influence against, a purely market-driven economy," unquote. Let me repeat that. The Chief Commissioner of the Ontario Human Rights Commission, the point of a human rights code is actually to be a countervailing influence against, a purely market-driven economy, unquote. They're not even trying anymore. They're not even trying to pretend that they respect people's fundamental freedoms. They're not even trying to pretend that they are not totalitarian czars who don't actually care about true human rights, like the ability to decide whether or not you want to work for a particular place. The ability to decide whether you are comfortable with a dress code. The ability to decide if you want to take advice from that line from the producers, and if you've got it, flaunt it. You know what? I've known a number of attractive men and women that have made huge bucks in the service industry because they know that they look good. And I know that I'm not a desirable quantity. Forget about the fact that I'm clumsy as all heck and would probably drop a lot of dishes. I know that because I did work when I was a teenager in the service sector, and I had trouble clearing tables, let alone serving tables. I've never done that before. But I know that if I were to walk into Moxie's and say I wanted, to pick up some extra cash on the weekends, and I said, you know what, I'd like to work for you, I know they'd look at me and sort of smile and nod, and I wouldn't get the job. Now, could I serve tables at a small diner? Sure. Could I tend bar at a hotel? Probably I could. But I'm not eye candy, and I'm aware of that. And unfortunately, there are a heck of a lot of ugly people that are most offended by these dress codes because they know they can't pull it off. They know they can't pull it off. And you know what? As a business, you need to put the best foot forward. Some places it's the food, other places it's the service, other places it is simply aesthetics. And I know this because I've been to places where the servers are absolutely dumb as nails and the food is terrible and you will not get what you order and you'll wait 3 times as long as you have to anyway. But my goodness, do they clean up well. And I think restaurants seem to know that. And I don't really care. I'm a consumer. I like food. I like restaurants. I like being able to decide what is most important to me as a consumer. That's how the market works. I was talking to a friend of mine about this, and she actually responded and said, what the Human Rights Commission is doing here is actually slut-shaming. They're saying that, it's actually offensive if you get attractive young ladies specifically, because let's face it, they're targeting females, to wear provocative clothing, or at least seemingly provocative clothing, because that's basically what they're saying here, that it's inherently sexual for a woman to show her cleavage or wear a short skirt. Now, the day after this came out, the restaurant Earl's changed its policy. They said all of a sudden they'll offer pants as a choice instead of skirts. How many of their servers will embrace that decision, we don't know. The ones that are there already clearly are already comfortable with the dress code. That's why they're working there. And there was a really interesting column about this also in The Sun by Sarah McIntyre, former Sun News contributor, and now a principal at Elbows Up Communication. And she writes, "Thank goodness there is a Human Rights Commission to save us. What is a girl to do? There's really nowhere else for them to work but in these misogynistic environments with their tatas hanging out, trying to garner an extra toonie in tips. How backwards, how paternalistic. Feminists have clearly jumped the shark and are now taking choices away from women." She writes, "These are private establishments. Women and men apply for employment, knowing full well the dress code. This isn't forced labor. There are alternatives, and no one is trapped into wearing a thong onesie," unquote. And ultimately, she said, you have to decide. Do you put your boundaries ahead of your paycheck? That's up to you. And she points out a parallel here that I find particularly interesting, which is that we're also seeing a country nationally that has moved towards legalized prostitution, or basically saying that this is something that women can choose for themselves. And she said, what's next? Is Kathleen Wynne going to ask Trudeau to rewrite the prostitution laws? Why is it okay to sell your body for sex but not wear a skirt while serving beer? And then there are the fundamental questions about how do you enforce this? What constitutes a sexualized dress code? You know, is it going to be like those school dances where you have a teacher going around and putting a ruler between people, where now you'll have a bureaucrat from the Human Rights Commission measuring the distance between waist and the bottom of the skirt? And let's face it, if you have a particularly, I'm going to regret saying this. This is, I'll just say it. If you have a big-breasted woman, a shirt might look a lot more provocative or revealing than it would on someone else. Does that mean it's a sexualizing garment, or does the body kind of sexualize itself in that way? Or is the Human Rights Commission the one that's doing the sexualization here? You know, I have a friend of mine who is a lot more, I'll say, liberated than I am. And she has told me that, you know what, she doesn't get what the big deal is about boobs. And she's the kind that would go up and down the street. I don't know if she does it. I'm sure she probably has. That would walk up and down the street or just take her top off at a beach or on a hot summer day in a park and not wonder what the big fuss was about. Because she's like, you know what? It's my body. I like it. I'm happy with it. If other people want to stare, who cares? If they want to look at me, that's fine. In fact, I think she actually said those exact words to me once when we were talking about it. Whereas me, I don't even like taking my shirt off on the beach. And I'm a guy. I have bigger boobs than some of the girls that do. But in any case, the point of the matter is, why can women not make these decisions for themselves? And men, for that matter. You know, I look at the Chippendales dance. I don't make a habit of looking at the Chippendales dancers, but I'm looking, figuratively speaking, at that whole thing. You know, a bunch of strapping, well-built, strong, muscular men that are wearing nothing but a bow tie and cuffs and pants. If there was a restaurant in downtown Toronto that wanted to have men wearing that, I assure you I would not be a contender, nor would I even try. Would the Human Rights Commission step in? According to the commissioner, yes. She said this doesn't matter whether you're looking at men or women. Wrong is wrong. But I have a feeling that they wouldn't take issue with that as being sexist because, well, it's only sexist if it's towards one particular sex. And my advice to them, men in that establishment, would be the same as advice to women who work at Hooters. If that is what you want to do, if that's going to help you, if you can make more money by flaunting your stuff, or you just don't care, power to you. If people are disgusted by it, if customers don't like it, then don't go there. If customers don't like it, they won't. But the fact of the matter is, the market has said this is okay, which is why it's so important that we recognize the absolute borderline fascism of the Human Rights Commissioner in saying that their job is to make sure the market doesn't exist on its own. To make sure that any market fluctuation, any market management, anything about business having autonomy over itself is filtered through this guise of human rights. Don't you feel so safe? Don't you feel so protected? Women listeners, do you feel like you are a more ingrained citizen in Canada right now because you'll never be forced? You'll never be forced. That's the implication here, to wear skimpy clothing at a restaurant. Give me a break. I've got to take a break here. When we come back in just a couple of moments, more Lawton Online here on the rebel.media. Stay tuned, Canada. We'll be right back.
You're listening to Lawton Online with your host, Andrew Lawton, exclusively on the rebel.media.
We are back here on Lawton Online. I said at the beginning of this program that the theme was going to be freedom today. And we talked about property rights. We talked about business rights, bodily rights, dress code rights, whatever the case may be. But freedom of speech, so paramount. And I mentioned to you that Lars Hedegaard will be joining me on the podcast next week to talk about that exact thing. But there was a free speech battle that was waged in Manitoba this week. Again, did not see any coverage in the mainstream media about it. Which is why I've always maintained that it's so important that places like the Rebel rise up and speak out about these things. But a film was to be screened at the University of Winnipeg. And it was going to enlighten students about an important women's reproductive health issue. Sounds boring, right? Sounds like the kind of thing guys are like, yeah, just whatever happens. I don't want to be involved. Well, that issue was abortion. Abortion is obviously an important topic politically, culturally, morally. And yes, it's a health issue as well. And you know my position on this. I am defiantly pro-life. And to me, this is obviously influenced by my Christian faith, but I think that someone can be pro-life for reasons that have nothing to do with faith or God or any spiritual concept. I think there's a medical case to be made. But I don't want to rehash that debate right now. It's not that I'm afraid to. I just don't think it's as relevant as making sure that people have the ability to have that debate. And this is the particular irony here. The movie itself was called Hush. Now, Hush is an award-winning documentary. It is touring Canada right now, with screenings on campuses across the country. I haven't seen it yet. I've seen clips of it, and I've seen the trailer for it and read some of the coverage of it. But what's particularly interesting about Hush is that it's actually a movie that is trying to bridge that gap between those who identify as pro-life and those who identify as pro-choice. It's trying to bridge that gap, and the film is actually the product of a collaboration between a pro-life producer and a pro-choice director. And they tried to, out of a mutual respect for each other and a belief that they believe in what's best for society, come together and see if they could overlook their differences. And from all that I've read, it seems like the process of making the film is likely as worthwhile a story as what was actually told in the film. But they wanted to look at abortion from the perspective of health only, not politics, not religion. And they wanted to peel back the curtain on some of these issues which really don't get discussed that often. That's why the movie's called Hush. It's as much about abortion as it is about people's willingness or ability to discuss abortion. So how ironic that that was the film that the University of Winnipeg decided to ban. A screening was scheduled for earlier this week, and the president's office at the university said, we aren't comfortable with it. They actually said they were not comfortable with it, quote, due to the content of the film, unquote. Now, this interview was recorded on Wednesday. So if you hear today, tomorrow in the interview, ignore that. I wanted to get this story out. I'm very pleased to be welcomed on the program by Tasha Deschambault, one of the coordinators of the tour of this film, Hush, across Canada. Tasha, thank you very much for coming on the program. I really do appreciate it.
Hi, thank you.
So for people that are not familiar with the film, I want to get to a little bit of the background of the movie here first, just to really set out why this is such an important film in your eyes for people to see here. What is the film? If you have to give that sort of one paragraph summary of it, what is it about?
Really, the film is about informing women on possible side effects of both abortion and miscarriage. And so the documentary takes a look at the possible link between breast cancer and abortion and miscarriage, especially in second and third trimester, as well as premature birth and possible damage to a woman's reproductive system as a result. So basically just a health risk from the operation. And as well as it takes a look at possible side effects with mental and emotional health as well.
And is this a documentary that's trying to lead people to the conclusion that either abortion is right or abortion is wrong?
No, that's a brilliant piece about the film. So it's good information. It's pro-information for women that has zero content on religion or politics. It really is the medical information that is often being suppressed, or that people in general just don't know about the possible side effects for women's health.
So this is a movie that has won awards. It's been receiving very interesting reviews from across the aisle on this issue. And it wasn't allowed at the University of Winnipeg. Now, what was the rationale that was actually given? Because I think that even if you were covering this from a very polarized, opinionated perspective, I would still say, hey, let's go show it. But especially given everything I know about this film, it seems all the more curious as to why they didn't want it shown in the university buildings.
Well, the email that I received from the campus's president was that they were not comfortable with the content of the film.
And did they break down what their objections to the content were, or just say it was just content?
Nope, it was just content. So there was no feedback or follow-up on what that was. So we really have no idea. And to the best of our knowledge, they did not see the film, as we only give it out personally, a personal invitation to a screening online. And so we're still unclear on what that content was that they were objecting.
And it's very difficult to respond to something to ameliorate concerns that are raised by someone in this context, because when you don't know what you're actually responding to.
Exactly.
So where has this left you as an organizer of this event, first off?
Well, we started scrambling late Sunday night to try and find another campus group that, or campus location, that would be close by. And so we actually put a SOS out on Facebook saying, hey, is there any location close to the university that would be willing to allow us to show the film? Because we knew there were students who were very interested and other people who were interested in seeing the film. Is there anybody that can help? And we did. We had somebody step up late yesterday who was able to give us a new location. Fortunately, it wasn't in time for last night, but we will be showing it tonight.
Okay, so from a perspective of getting the message out, getting the film up, you found a resolution here, which is good.
Correct.
But it doesn't deal with the underlying bigger problem here, which is a university, a publicly funded university, a place for higher learning, for growth, for edification, where ideas should be challenged, not wanting to see something that might challenge ideas.
Yeah, exactly. And, some of our concerns is many of the women that undergo the procedure are in this age range typically. And so this is good information for them to have so that they can really be making an informed decision about their health. And it's not just short-term health either. This is some women have very long-term side effects as a result of an abortion. And more often than not, we're finding that these women are not receiving this information, that these are possibilities for them like you would with any other medical procedure. And so really they're left unaware of these possible side effects.
And I think that for an issue like this as well, where there is so much of a very heated and very polar discussion that can go on from, as you mentioned earlier, the religious side, the political side, having one that is sort of recognized and understood to be just looking at the medical side, if anything, seems like one of the, for lack of a better term, most quote-unquote comfortable situations there could be for an approach to this issue. So it's concerning that the school has said, using that exact same word, that they were not comfortable with it.
Yeah, exactly. And we have done really every effort to make this clearly pro-information, pro-women's health. This really has no hidden agendas. And we had a screening at U of M on Monday here in Winnipeg, and we had everybody except for one person fill out the evaluation form, and 100% of those forms were positive feedback regarding the information in the film. So this really has left us a little bit of mist as to what part of this content would be causing them to be uncomfortable.
So we've talked about the fact that thankfully there has been a resolution. The screening will go ahead. I'm curious, what's next for the tour? Where are you really hoping this film and its message expands to?
Well, we're going right across the nation. So we started in Manitoba. From here, we'll be taking it right over to the East Coast into Toronto, Kingston. We have a screening tomorrow night in Brandon. And then from there, we're branching into the United States as well, and there's about 10 campuses that we intend on bringing the film to. And then later in the fall, we're hoping to bring it into theaters, but we also have an availability for people who are interested to see it sooner. They can either pre-order the disc for the documentary, or they can have a private screening in their home if they go to our funding campaign online.
So has there been any issue yet with any of the other locations and venues as far as this goes, or is the University of Winnipeg an outlier at this time?
No, at this point, they're an outlier.
Good.
This is our only controversy at this point.
All right. Well, let's hope it stays that way. I'm joined on the line by Tasha Deschambault, one of the organizers of the tour of the film Hush. We have some information about that on our Facebook page. Tasha, thanks so much for joining me this afternoon.
Thank you for having us.
I've always said that universities and colleges are these microcosms of society, but they seem to exist based on rules and laws and basically a level of sense or lack thereof that doesn't seem to exist in the real world. Now, unfortunately, it's translating to the real world. I mean, the irony here is just too delicious. A film about free speech, about an important issue, banned because people don't want to talk about the issue. Talk about reinforcing the need for a film like this. And yes, for the organizers, I'm glad for their benefit that they were able to work around this. They're able to have their event. But that should never have had to happen in the first place. And I have experience in this area. I don't know how much detail I've given in the past about this topic on the podcast, but I was in 2010 part of a group along with the International Free Press Society Canada and a number of students at my alma mater, Western University, involved in putting together a tour, a small speaking tour by a prominent speaker that went to 3 schools. That speaker, you may have heard of her. Her name's Ann Coulter. Event number 1 was to be at Western University. I think it was called the University of Western Ontario then. Event number 2, Ottawa University. And event number 3, University of Calgary. Ann Coulter had never spoken in Canada before. This was back before she seemed to have her falling out with a lot of conservatives. Very much a big deal. She had had just another best-selling book at the time, and it was actually coming up on 6 years ago this month. It was in March 2010. So Ann Coulter was to speak at Western, then Ottawa, then Calgary. And days before the event, the Ottawa U Provo had sent a letter to Ann Coulter went through a number of channels to get to her, warning her of the possibility that she may face criminal charges for hate speech. For a speech she hadn't given yet, she said for a speech she hadn't even written yet. And to be cautious, to be careful. Well, as a result of that, protesters mounted. I was more directly involved with the London event specifically. And what happened there was organizers on campus didn't try to ban the event. Or not organizers, rather, administrators on campus. They didn't try to ban the event. But they tried to ban by default, which is a tactic we've seen so often. They hit security fees, requirements of sorts, costs, the need to get a certain room, the availability of rooms, all of these different things. And you have to be prepared to go in there and advocate and fight. And we've seen universities do this as well with pro-life groups specifically. Oh yeah, you can have your event, but you need to spend $10,000 in security fees. And this is the way they can say, oh no, we aren't censoring. They could have done it. They just didn't want to pay the fee. Now, to Western's credit, everything worked out fine. The event went ahead as planned. It was a great day. And in Ottawa, it was a different story. The next day, thousands of people outside the venue, hundreds, if not thousands of protesters. People had posted online rape threats against Dan Coulter, the enlightened, tolerant left. Wanted to rape her. People were talking about wanting to throw rocks at her. Her security and safety could not be guaranteed. The event had to be canceled at the last minute. Now, if you want a tale of two cities here, what does the University of Calgary do? Say, hey, do you need a bigger room? And yeah, they did. We did. But this is not a new idea. And I see almost every week, especially in the U.S., cases where this is still happening, except now it's not Ann Coulter. Now it's Ben Shapiro, Milo Yiannopoulos of Breitbart. Other similar voices, people like David Horowitz. Conservatives who want to do nothing other than speak to a group of like-minded people, or even detractors, by the way. That's the funny part of it, is that the left wants to shout these events down. When in actuality, I think the right would love nothing more than for the left to show up, ask a sensible question, have a debate, but they don't want to do that. They don't want to do that. They just want to say, no, it shouldn't be heard at all. And that was the fascinating part about the Ann Coulter thing. People didn't say, she's terrible, she's toxic, you shouldn't go. People said she's terrible, she's toxic, she should be banned, she shouldn't be allowed to speak. I've seen it with Mark Steyn as well, who's going to be back in Canada, back in Toronto specifically, April 1st for a debate on immigration, which I'm going to be at, will absolutely be wonderful. And the list goes on and on of people that have been banned or condemned by universities, student groups that have tried to advance a particular point of view. And I'm glad that there are so many pro-life groups that are on campuses, because I think it is an important issue. And as Tasha Deschambault mentioned, that demographic of young university and college-age students is ultimately the one that I think needs to be most exposed to this issue. And I'm not even talking about whether you think life begins at conception, whether you think that a woman should be able to have unlimited abortion up until one moment before her child is born. I'm talking about a belief that this debate should never be shut down, nor should any debate for that matter. That people have a right and a duty and an obligation to facilitate debate, to facilitate disagreement. Healthy, robust, peaceful disagreement, sensible debate. And this is why I said earlier that I think the collaboration between the pro-life producer and the pro-choice director is in and of itself a model on this issue. I mean, obviously there are some of these rabid pro-choicers that don't want to see any debate on the issue at all. And conversely, there are pro-lifers that are similarly unreasonable. The left doesn't have a monopoly on this issue, I assure you. And look, I'm an unabashed pro-lifer, but I also think that there are understandable concessions that people are advocating for on this issue, on this subject. And you have people on the right that don't believe there is any wiggle room. And you have people on the left that don't believe there's any wiggle room, that don't think maybe limiting, hey, no abortions in third trimester would be a legitimate law. And I realize I'm breaking my promise. I said I wasn't going to get into the issue. It's not because I don't want to. It's more because it's one of those ones where I feel you're either preaching to the choir or you're speaking to a group that doesn't want to hear about it. But when there are people who are undecideds, when there are people who want to hear either side, why should they be denied that right? You know, I've done a number of public speaking engagements at pro-life groups, and I've actually done a lot of moderating of these debates, of pro-life, pro-choice debates. And what's really funny here is that the group that I've done this through is a pro-life group, and they organize debates on campuses, and they bring in professors or doctors typically to debate the pro-choice position. And I've had a few times where they've responded, the protest or the pro-choice person has responded and said, oh, well, you know, he's pro-life, how can he be a moderator? And then they just show video of when I do it. And in all honesty, I think it's compensation, overcompensation, because I think I'm harder on the pro-life people in the debates when I'm moderating. But ultimately, I've never had a complaint, never had any issues. And when I need to put on my impartial hat, I can. But what's interesting about it is that when these debates happen, they are so much fun to watch because you see the power of debate and disagreement and the power of discourse. And this isn't to say for a second that every opinion is worth acknowledging. I mean, this isn't to say that we should be hosting debates about, oh, did the Holocaust actually happen on campuses? But at the same time, if someone wanted to, and I were a Jewish group on campus, would I say this is offensive? To say that the Holocaust never happened is offensive. Absolutely, I'd say that. But I would darn well hope that no group in that situation would ever say they don't have the right to make that appeal. The correct remedy for a bad idea is a better idea. Do not make zealots martyrs. It's what they want. And it doesn't work. And always stand up for freedom. Friends, I have to sign off for this week, but I'll be back next week with a show that I, based on what's already in the works, think will be one of my favorites. You're listening to Lawton Online here on the Rebel.media. I'm Andrew Lawton. Thank you, take care, and God bless you.
Thanks for tuning in to Lawton Online. Check out the Rebel.media for lots more fearless content and commentary.